It's a great honour to be invited to speak as part of this important series. I have listened to a number of the speeches this year and last year, including those given by the Chief Justice, Justice Andrew Greenwood of the Federal Court, who was another who was appointed directly from the Solicitor's branch to a court, and Di Fingleton, the former Chief Magistrate. I know that the Society, both in its professional development courses on advocacy and through Proctor, has strongly promoted the concept of solicitor advocates, including an editorial I found in Proctor in 2017 that traversed history from the ancient Greeks through the Roman Empire in support of the author's hypothesis that solicitors were the original advocates. So they were the scribes to the bar's Pharisees. I think advocacy is a calling. Some solicitors have it, some don't. Some barristers have it, some don't. But for them, there's not much room to move somewhere else. Those of you who were unfortunate enough to attend my lecture at the symposium earlier this year will have to forgive me because I'm going to recycle some of that material, but without the silly videos. I thought the seriousness of the occasion forbade me from introducing you again to Steve, who was found driving a lawnmower while drunk. But clearly the organisers from QLS don't learn much because they've invited me to speak at the symposium again next year. But this time my topic is developments in the criminal law, so there won't be much scope for humour in that topic. Even from that cursory research, I'm aware that all of you are aware of the ethical and legal framework in which you work, which governs your work as advocates before courts or tribunals. There are some very fine advocates in this audience tonight, and I can teach you little. For those reasons, I thought of an approach which re-emphasised the fundamentals, but also explores other issues that don't commonly arise in talks about advocacy. I was told by Ken and also Stafford that war stories are popular for this audience at this time of day, so like it or not, you're going to get some war stories. But I hope that you'll learn from the telling rather than seeing them as completely self-indulgent, which of course that's exactly what they are. When I commenced practice as a solicitor, our branch of the profession had only recently been given right of audience in the superior courts. Things have certainly changed. Some of you are probably aware that in London, barristers are actually protesting, even marching in the streets about changes in legal aid funding which favours solicitor advocates, even doing trial work in the Crown law, and money is not going to the barristers. The approach to training and advocacy in my early years was a bit like teaching a bush kid to swim. Throw them in the deep end and see how they go. I got my first taste of advocacy on my third day of work. I'd come from being what was then known as a clerk to a district court judge. It was only later that we were promoted to being called associates. So I'd had some contact with advocacy in the court system, but I had a wonderful mentor in my first years as a solicitor, a man named John Elliott, who was deputy editor of the Courier Mail for a while. Then he was a barrister, then solicitor, and that's when I first met him. And then finally he was a family court judge. And he was a man of wisdom and humility, and when I arrived, pretty self-confident. His sense of humour, I think, was piqued, and he thought it would be fun to throw me into the deep end early. I wasn't yet admitted, and that wasn't a problem in the very pragmatic Land Court, where I was given leave to appear, and there was an advocate from the Valuer General's Department, and I was there contesting a decision about quantum of land tax, and I was successful. I had the land tax increase overturned. I was never to appear in that court again. But the following week I found my real love, and that was advocacy in the criminal court. It was a very serious case. My client was charged with stealing a hose fitting from Woolworths. Once again, John decided to throw me in, again with little guidance, apart from see if you can take some of your land court form into the Queensland Magistrates Court. As it turned out, I had some limited experience with that court. It was a truly brutal court in those days, but a few days before I'd attended the number 1 police court in George Street, where Adelaide Street now joins North Quay, to represent a drink driver before Chief Stipendiary Magistrate Fagg. That really was his name, Chief Stipendiary Magistrate Fagg, and no one ever smiled when they addressed him. I was there for the daily and what was a really unseemly appearance of all those locked up in the previous 24 hours for public drunkenness. It was known as the Drunks Parade. And during that period, and over the next couple of years, I witnessed some sublime feats of advocacy from some of those punters, most of whom were still drunk, and many of whom had literally had thousands of appearances in that court. It was an intoxicating time because for an hour, as each drunk was processed, the ancient courtroom smelt like a bar after closing time. As each defendant's matter was mentioned, the police prosecutor would grandly announce, "This is Mr. Robertson's 1076th appearance before this court for public drunkenness." That would lead the remaining punters to applaud, which led to a rebuke from Chief Stipendiary Magistrate Fagg. My advocacy training started with Drunks Parade member number 22. He told his worship, and they were worshipped, not honoured in those days, that as it was May and it was getting cold in the streets, he should be sentenced to at least 4 months to get him through the winter. His worship was having none of this, and he settled on a month. The punter got very upset and he objected strenuously and argued with his worship. And finally his worship responded very firmly, "Now you be quiet. If you don't shut up, I won't send you to prison at all." I return now to my first outing in an actual hearing, a committal hearing, in the Magistrates Court. I drew one of the best magistrates, Stipendiary Magistrate Anderson. His nickname was Tosser Anderson, because he was one of the few who dared occasionally to defy the police by failing to commit and finding there was no case to answer. He was a lovely man. In those days, there were no digital or audio recorders. Instead, it was a grumpy old depositions clerk who typed the proceedings down slowly on an old touch typewriter. At the end of each page, he'd hold up his hand and say, "Stop." He'd then extract what were 3 pieces of rice paper interleaved with carbon paper from the ancient machine. He'd carefully place it to the right-hand side. He'd reconstruct the next page and wind it into the machine. And then he'd put up his hand again to tell us we could proceed. That committal for shoplifting went for 3 whole days, mainly because of the lethargy of the depositions clerk. It was wonderful training because it actually gave you time to think. Even when you were halfway through a question, you'd be stopped. So it was a wonderful way to think about your question before you answered it. In any event, it was an absolute wonderful success. I convinced His Worship not to commit. My client was ecstatic, and so was I, and I was hooked. And all because an old man, and he was about my age now, forgot to pay for a hose fitting as he was leaving Woolworths. As you know, advocacy is an art. You can learn much about the techniques of good advocacy, but in the end, some have that secret ingredient that places them in that rare group, the really brilliant advocate. Most in this room won't remember Dan Casey, but he was certainly one of the most brilliant of advocates in the criminal court. And a recent example, but not from the law, Paul Keating was a great advocate. He had great powers of persuasion, although his methods in Parliament probably would have got him into serious trouble in a court of law. I use the adjective pretend in my title deliberately because I can't tell you what that secret ingredient is. I've also used the word to qualify the other dubious claim in the title, that I'm an expert in advocacy. I've spoken about the topic to groups as diverse as students of law and journalism, judges, prosecutors, defence barristers and solicitors and journalists over the years. I've been involved in hypotheticals and debates at conferences with journalists about advocacy. So for some reason, I've been tagged as having some expertise in the area. As I noted before, when I first started to appear in the higher courts, solicitors had only recently been given right of audience. There was a lot of misgivings, particularly from senior members of the bar and from a lot of judges. But I can honestly say I was never met once with animosity or undeserved contempt. There were many times when I sweated heavily and felt under a great deal of pressure, but it was always appropriate. The late Judge Kimmins, father of the Kimmins boys at the bar now, could be bitingly sarcastic, but usually for good reason. One of his famous statements was, "I was thinking of giving your client probation, but you're going on and on and on, and you're going to talk me out of it." My first Supreme Court sentence was in about 1976, when I was appearing for a former school colleague who was pleading guilty to supplying heroin. It was a love job. The judge was none other than the legendary Peter Connolly. Justice Connolly had a justifiable reputation for intolerance, for irrelevant and stupid submissions. That's the Justice Connolly who threw the Supreme Court rules over his shoulder when a solicitor advocate announced his appearance and said that he was from such and such a firm of Surfers Paradise, and His Honour threw the rules over his shoulder and said, "Well, we won't be needing these." I was extremely nervous and apprehensive when I approached this task because I even had the audacity to call evidence. He was a judge who always seemed to be impatient, and probably was. And I called evidence. I called a police officer to give evidence in camera about my client's assistance. This is back in the days before Section 13A. A few years before that first appearance on my own, I had instructed John Gerard, later to be on the Court of Appeal, before Mr Justice Connolly. My client was the notorious and also late Bill Phillips. Bill had returned to his home in Vulture Street, West End, after a long stint in a Belgian prison for large-scale drug dealing. Very soon after he arrived back, there was a raid by what was then called the Drug Squad, and Bill was charged with an offence under the old Health Act of suffering premises to be used for the purpose of use of heroin. Because of his record, of course, he was remanded in custody, and by the time I became his lawyer, I think I was number 4, he had served a lot of time in Bogger Road on remand. The trial was set to proceed in about 2 weeks' time before Justice Connolly and I briefed John Gerard late. He and I negotiated with the prosecutor and who agreed to accept a plea to possession of heroin simpliciter. Billy Phillips was a tattooist, He was an early version of a walking, talking billboard advertising his wares. That is the tattoo side, not the drugs. Justice Connolly wasn't pleased with the idea of having to hear what was in fact a summary matter in the Supreme Court. He was not happy. When Gerard got to his feet, he commenced by saying rather dramatically, "Your Honour, my client's story begins with the World Conference of Tattooists in Amsterdam in 1968. There was an intake of breath from the bench. The judge struck his forehead and said, 'Spare me, Mr. Gerard, spare me. I was thinking of a good behaviour bond if you stop right there.'" When I look back over the decades of papers and articles and lectures that I've given and published, I started to develop a sinking suspicion that it was not my experience that was being tapped. Rather, like the symposium this year, I was often given the graveyard shift at conferences, where everyone is conferenced out, or if it's a criminal law conference and O'Gorman's there, everyone's hungover. An example is when Alan Wilson QC, formerly of the District and the Supreme Court, of fine intellect, who in his retirement speech in the Supreme Court set an IED under the judicial appointment process. You'll remember that, or at least one aspect of it. He asked me to speak on jury communication at a National Judges Conference on the Gold Coast in 2003, but you made it very clear that it was to be light-hearted, because my speech was the last of the day, following a speech from another judge on Mariva injunctions, and even worse still, a speech from a New South Wales judge on loss of opportunity in assessment of damages in personal injuries cases. So he said, make it light-hearted. I ended up doing things like having the late, everyone's late, you see how old I am, the late Senior Judge Skane, a dear friend, recited the bench book direction on provocation based on the High Court case of Stingle in French. Even the non-French speakers thought that the French version was more comprehensible than the English version. It was a big success. At that time, there was a direction known as the Weisensteiner direction. Some of you who have been in the criminal law for a while will remember it. It effectively allowed a trial judge to undermine the onus of proof by commenting adversely on a defendant's failure to give or call evidence. It was based on a Queensland case, a murder case. It didn't survive long, but it was still in existence at the time, so it was also a very complex direction. So I arranged for a Victorian County Court judge, Judge Michael Strong, who was a trained opera singer, to sing it. And once again, everyone thought that was a much better communication, and they finally understood what Weisensteiner was all about. Now you see, advocacy is really the art of persuasion. It's all about good, clear and straightforward communication. The baby alligator has stated its case, you might think, very clearly. It's likely to be successful in its plea. I should also mention that I've used this slide in other talks to highlight the difficulties facing heads of jurisdiction who receive complaints about colleagues. Judge Renato, Chief Magistrate, wasn't all that impressed with being associated with, I thought it quite handsome alligator, but he understood the point. Like Queensland, I'm certain that particular swamp doesn't have the alligator equivalent of the New South Wales Judicial Commission. Concentrating on advocacy in the sentencing process, it's axiomatic that in almost every case you'll have one or two good points. You won't have any more. The good advocate concentrates on those. The same observation applies with written submissions, which I always found very helpful. A short submission, well argued, which concentrates on your best arguments, is much more likely to persuade than a long, discursive submission in which the good points may be completely buried by the garbage of the bad. It is much more difficult and challenging, I think, to trim down a submission to only the good points. And Twain's truism hints at the title that I've chosen for my lecture tonight. It follows that to achieve potent brevity, it's necessary for the advocate to prepare in exacting detail. That's where the time should be spent. When reflecting on a long career in which advocacy, both delivered and received, has played such a large part, it occurred to me that we're now extremely time poor. In the digital age, it's easy for parties, the prosecution and the defence, to dump large quantities of material on the other side, sometimes at the last minute, including a large number of so-called comparable cases. This can happen, for example, from the defence side, where there's a psychological or a psychiatric report of considerable length, which doesn't identify any mental disorder or disease that might affect the sentence, but is sent to the judge really to save the advocate time in setting out the antecedents of the client. Of course, in the psychological report, that's the antecedents of the client from his or her point of view, and it's unlikely to be very helpful. The sheer number of cases that are now pushed through can be overwhelming, particularly to that most noble of advocate who appears most frequently in the magistrate's court. We're set about with all sorts of process requirements. There's case management, directions, hearings, other requirements that can take more time to manage than can the disposition of the case itself. Judicial officers feel it too, particularly where the caseloads are large and intense. In 2008, I participated in a sentencing workshop facilitated by the Bar Association. Participants were given in advance a transcript of a sentencing hearing that I prepared. It was hypothetical, but laced with actual submissions and actions taken by lawyers who had appeared during sentence hearings before me as advocates. I described it in my introductory remarks as an amalgam of actual bloopers. For example, a fraud case in which the outcome was really 50-50, and it was a case that was really concerning me. The advocate handed up a huge quantity of documentary material. So much so I had to adjourn for a couple of hours to read it all. And as I read, I realised that most of it, if not all of it, was completely irrelevant to the real issue in the case. There were even two copies of the same electricity bill. And when I went back into court, I pointed this out to the advocate, who obviously hadn't read the document. And his excuse was that his client insisted that he handed up to me. Well, of course, that's not an instruction that you're bound to follow. Or even worse, a case in the regions in the 1990s. And my daughter Caroline may have been my associate at the time, but it was a sentence, and an 18-year-old intellectually impaired defendant was pleading guilty to sexually touching his 15-year-old friend, who was also intellectually impaired, during a car journey where they were in the back seat and their carers were in the front. The defence advocate handed up a psychiatric report, the learned author of which had opined that this extremely challenged young man was a pedophile. It was clear that the advocate hadn't read it. I made him read it there in court, and then with the prosecutor's consent, I allowed him to withdraw the tender. One of the positive developments since then is that, at least in the higher courts and to some extent in the magistrates' court where long pleas are scheduled, the judicial officer will often be provided with a lot of material before the actual hearing, including a schedule of agreed facts and copies of comparable decisions and other materials. In almost every case of poor advocacy, it's almost always due to a lack of preparation. I accept that in this day of low legal aid funding and limited resources, this is to some extent understandable. But the reality is that if you are appearing, your ethical duties require you to do your best for the client and to properly assist the court. In a paper given to the North Queensland Law Association conference in Cairns earlier this year, Justice Henry, in collaboration with Judges Clare and Lynham, identified a number of common advocacy errors, and unsurprisingly, they were the same errors that were identified in that workshop that I led in 2008. These include making dubious submissions as to range and outcome without reference to any authority, tendering documents that are illegible or incomplete, tendering documents that are legally inadmissible or irrelevant, for example, criminal histories containing juvenile entries. I mentioned in the hypothetical, and this happened more than once, having a large number of documents handed up which included a grade 1 certificate of participation and a copy of a ribbon for a swimming competition in grade 3. It's actually happened. Tendering documents that have not been read, such as a psychiatric report, which are prejudicial to the tendering party, and referring to cases that are not comparable, or my pet hate, handing up large, unedited, unread extracts from legal databases, for example, the legal aid sentencing database. Perversely, another problem that arises rarely, but in my later years, it seemed to happen more commonly, and that is where it was clear that the advocate had absolutely no commitment to his or her case. And the submissions were egregiously brief and didn't touch on the real issues in mitigation. All of you would have heard of that description based on the cricket analogy of rolling your arm over. That's a serious problem. Once again, I acknowledge that if you are appearing as duty lawyer and you are on your 10th case for the day and the client is a Magna Carta specialist, or even worse, a non-person, those standards are hard to maintain, but fine and dedicated lawyers do that day in, day out in our courts. As I've stressed, the key to good advocacy is preparation, and that may even just mean taking a few minutes to gather your thoughts and focus on the important issues in the particular case. In the magistrates' court, where the caseload is so heavy, it's necessary to be focused and to the point, otherwise you'll upset the magistrate, who's also under pressure. This brings me to another aspect of advocacy that's not often discussed in papers on this topic. Perhaps the greatest challenge to an inexperienced advocate, but also to the seasoned one, is the angry and/or stupid and/or unpleasant judge. This guy. He's American. I had a picture of Donald Trump, but I thought that was inappropriate. They do pop up from time to time. In my day, they were always men. These days, with more women on courts, the gender inequality on this issue is less obvious. In a recent paper to the JCA colloquium in Melbourne, former federal and Victorian Court of Appeal Judge Mark Weinberg tackled this issue in a very interesting way. He'd analysed many speeches on what makes a good judge and realised that there were very few papers on what makes a bad judge. So he decided to focus on that aspect. A bad judge is a real challenge, not only to advocates, but to really fundamental issues, such as judicial independence, fairness and impartiality, and confidence in the judicial system. Mark Weinberg identified many features of the bad judge, and I'll mention some of them. A bad judge tends to forget that the most important person in court is certainly not him or her. He referred to an over-speaking judge, described such a person as not a well-tuned cymbal. The musical side of me thought, you don't actually tune a cymbal. They're just different sizes, but I'll move on. Related to this is excessive intervention. On the other hand, there's the judge who's sphinx-like. He doesn't show any animation. He doesn't respond to any of your submissions and conveys nothing about what he or she is thinking. And as Weinberg said, in some ways, that judge can be even worse than the judge who talks too much. As he notes, in his understated way, impatience is perhaps the most common fault in judicial character. He points out that the consequence almost as always is to lengthen, not shorten, the hearing. Failure to appreciate that the lawyers appearing before the judge almost certainly will know a lot more about the case than does the judge. This one I really liked because I think I suffered from this a little bit for a couple of years, maybe longer. Supposed omniscience and all too real pomposity, often associated with newly appointed judges who may find the excessive sycophancy of the advocates who appear before them too much for their liking. He mentions bias, actual or even apprehended in court, which may arise from a dislike of the advocates or an advocate appearing in the case, or a different view as to how the case should be run. It may even arise from sheer boredom, which is a feature of the tedious and repetitive job of judging. He mentions, of course, bullying of counsel, which he describes as cowardly and always unacceptable. Incidentally, he talks always about counsel because he comes from that. So he was an academic, actually, but then went to the Victorian Bar. They always forget about solicitors. The inability to cope with self-represented litigants, as he said, some of whom would try the patience of a saint. Indecisiveness, procrastination, an inability to control the conduct of the proceedings, lack of a sense of humour. I don't think I suffered from that one. I often had to censor my witty remarks before they came out of my mouth. Inability to get on with one's colleagues and inappropriately offensive remarks. My research for this paper with lawyers who are presently in practice has identified that at the present time there are indeed a small but a persistent number who regularly behave like a bad judge. Remarkably, in this day and age, they seem to be completely undeterred by the fact that everything is being recorded. I recall an appeal in the last couple of years where the magistrate made a sotto voce comment after the self-represented litigant refused to plead guilty, and before the trial came on, and the magistrate made a comment to the police prosecutor which didn't appear in the transcript, which one could hear in the audio recording. It didn't affect the outcome of the appeal, but it's amazing that they don't think all this is being recorded. On and on they go. As I say, there are just a few of them, and I'm reliably informed that there are bullies, some of whom shout and even swear at lawyer and litigant alike. Some who have a wrong and idiosyncratic view of the law, which, despite appellate criticism, they continue to follow. The first reaction when faced with an odious abuser of power like this is a bit like the fox in this slide. However, it is a very serious issue. These people have literally ruined careers. They've perpetrated serious injustices on citizens. They embarrass their colleagues. They breach fundamental principles of justice. In any other workplace, they'd be sacked. The Socratic method sometimes calls for forceful exchange between bench and advocate. That's part of what is involved in advocacy, but there's never any excuse for bullying or abuse. Believe it or not, my research discovered that this also happens in New South Wales. I found that really surprising. But down there, those rare miscreants can be dealt with by the New South Wales Judicial Commission. And this has the very good effect of enhancing the authority of the heads of jurisdiction, and it acts as a deterrent to others like the newly appointed sycophant who may be tempted to stray down that path. At the moment in Queensland, as you probably know, when there is a complaint about a judge, particularly of bullying and misbehaviour in the courtroom, it's left to the heads of jurisdiction to deal with that internally and confidentially. In many ways, it's quite a good system. But for the unrepentant bully, he or she knows that ultimately there's nothing that can be done apart from transferring the culprit from one district to another, which is a practice that hasn't worked terribly well for other institutions, or cutting off the number of cases in their list, which of course is unfair to the other members of the court. So I say to you that if you have the misfortune to encounter one of these people, I go back to one of my favourite authors, Mark Twain, who said this: "Courage is resistant to fear, mastery of fear, not absence of fear." So it's okay to be extremely nervous and upset and even afraid when faced with one of these people. But politely and forcefully stand up to them. Put your objections on the record. Tell the judge or magistrate that they're being recorded. Remind them. I can recall being involved in a trial, again in the 70s, in the district court where there was a jury. There was a period in the 70s where conspiracy became the charge of choice. I think in all my years as a judge, I think I did 2 conspiracy trials. But every second client was charged with conspiracy, usually conspiracy to defraud. I always thought it was a refuge of a prosecution that had a weak substantive case, so they'd charge conspiracy and bring in others. It involved, as I recall, about 5 people and something to do with a scam involving plantation trees. The judge was one of them. That's a bully, not a defendant. A fearless advocate for one of the other defendants was on his feet addressing the jury at the end of the trial. His name was Des Drayden. The judge constantly sighed and gesticulated to the jury during Des's address, demonstrating and conveying his contempt for the submissions that were being made. In those days, of course, there were no audio recordings, only those wonderful shorthand writers who could transcribe at the speed of light. So the judge knew that none of his behaviour was being recorded. Des stopped mid-sentence and he said, "Your Honour is continuously making noises and gestures towards a jury designed to undermine my arguments. I object in the strongest terms and ask you to cease your behaviour." Without thinking, the judge said, "I'm doing no such thing, Mr. Drayden. How dare you accuse me of such behaviour?" The looks on the face of all the jurors conveyed one message: "Oh, yes, you are. You liar." And that was the end of the prosecution case. Despite the judge's attempts in a biased and unfair summing up to get convictions, the jury acquitted all 5 in 20 minutes, and that was after a 4-week trial. Of course, for the last 24 years leading up to my retirement in May, I only had personal experience of one judge. He was kind to children and animals, good at hiding his legal failings, almost always courteous, almost always interested, even in the self-represented litigants. In fact, he found them fascinating. He was not a bully, well, maybe once or twice under severe provocation, So I'm very grateful to my researchers for giving me the information, including access to transcripts about these people that I've mentioned, all of whom I thought had retired when I was appointed. Once again, can I thank Ken and the Society and Stafford for inviting me to participate in this important series. I'm very proud of my time as a solicitor, and I'm proud of the fact that I'm a life member of QLS. I'm also, as of recent times, a life member of my beloved Sunshine Coast Law Association. I loved advocacy, and as I said before, the buzz of successfully persuading a court to a particular result by good advocacy is almost existential in its effect. I hope that in my brief remarks I've given you the courage to take it on. One last war story. I recall going too far once in the district court on a sentence hearing before a truly wonderful judge, the late and great Leo McNamara, father-in-law of Judge David Andrews. Not only did the judge cry during my submissions, but so did I. So what I say to you is be courageous, be prepared, keep it simple, and don't cry. It's self-indulgent. Thank you.
Can I say this, John? Your reminiscing has brought to my attention that when I first started in the law, I was a article clerk in Sandgate, and the Sandgate Magistrates Court had a tin roof, and our depositions clerk had to stop every time it rained.
Yeah.
The second matter you brought to my attention is Judge Conley, because on the day of my admission, I was actually doing my first trial before him, being led by the late Tom Trembuff, if you remember Tom.
I do.
And I remember that by the fact that he gave permission grudgingly to allow me to go to the full court to be admitted and come back very, very quickly. So I certainly do remember those matters. Can I ask, is anyone wanting to ask of John of any questions? Because this is an opportunity.
Doing some more war stories.
Yes, because this is truly an opportunity to gain insights from a man who has been both a successful solicitor advocate and a wonderful judge.
Well, sometimes successful. I do recall, and there's a lesson in this. There was a wonderful judge who's also deceased. Everyone's dead.
Yes. Except to you and I, John. Yeah.
Judge Maguire, and those of you will remember him. He was his nickname was Front Page Freddie, because he loved a headline. He was a thoroughly decent and lovely man. He did I think the last abortion trial in Queensland, and his rulings were followed in many other courts in the common law world. But I can remember appearing for a fraudster, and this fellow was a travel agent. This was a difficult brief. The only work he did were for religious people. So he'd organised tours of the Vatican for Sisters of Mercy, and so all his work came from church and religious groups. And he'd pinched about $500,000 of money that had been paid in advance by these people for tours that they were never going to take. They weren't going to see the Holy Father in St. Peter's. And none of it could be paid back. He was bankrupt. So I was starting from way back with Freddie, because Freddie was just outraged. And whatever sentence I submitted for, Freddie doubled it. And of course the press were all over it. And as I came out, I was angry. I thought I was probably a bit low, but Freddie was far too high. As I came out, someone from probably the Courier Mail said, "What did you think of the sentence?" And I said, without thinking, Front Page Freddie at it again. And as soon as the words came out of my mouth, oh, here's the Courier. But the journalist was a decent man back in the days when they were a decent man, a man called Mark Oberhardt. And I stopped and I said quietly, "Mark, please don't publish that. And he said, of course I won't. But it just goes to show, I mean, these days it's part of the deal, isn't it? Fortunately or unfortunately, people have different views of saying something to the press as you're leaving court after an appearance. You've got to be very careful and cautious in what you say, because it can affect not only the outcome, which is bad, but worse, your career prospects.
I believe there is one question.
It's
No, I refuse to answer any questions from that man on the grounds that I'll certainly incriminate myself.
well, it's really a shameless comment dressed up as a question. John McInnes from Legal Aid. My ears pricked up, and I wish I had known a long time ago what I just learned tonight, and that is that you were mentored by an editor of the Courier Mail. I would have structured my submissions differently.
Deputy.
Deputy.
Yeah, you always had your facts almost right.
So a Goebbels, not a Hitler then. And so in order to try and dress that comment up as a question, it leads to this. Which of the following 6 rules is the more important? Know your judge, know your judge, know your judge, or know your brief, know your brief, know your brief?
Well, you know, what's that quote? A good lawyer knows the law, an even better lawyer knows the judge. But I think, look, back in the day, judge shopping was rife. Look, it was never going to go on because the judges... I've told this story in public before, so I can tell it again. The first Chief Judge that I served under was Pat Shanahan, who's of the old style, the old Catholic defence lawyer, a wonderful jurist. But he'd say things that were just gobsmackingly outrageous. But he divided his court into 3 groups when it came to sentencing. There was the A team, and they were the tough guys. Then there was the B team. They were sort of the mid-range, could be tough, and then there were the marshmallows. And I was always in the marshmallows, you see. So that meant that if I was in the list, and this actually happened, and I volunteered foolishly one day to come down from Ipswich to do some sentences in Brisbane. The other judge in the list doing sentences was in the A team, and suddenly all the cases were shifted to my list, and he went home at 10:30, and I worked on till 8 o'clock that night. And going back to one of those errors that I referred to, making submissions about penalty that are simply outrageous and not supported by authority. The last case on that day was, and I was tired and a little testy. 2 young men who'd done some break and enters. They were both 18, no previous convictions. Some of the property was lost, but some had been returned, early plea, etc., etc. The prosecutor, who's now a judicial officer, but he had a nickname that included death.
Oh, yeah.
He stood up and said, the starting point's 3 to 4 years. And I was outraged by that submission because it was unsupportable by any authority. And it is something to be very careful about when you're arguing for a particular result without being prepared to argue and support your submission by reference to at least some authority. That's harder, of course, in the magistrates' court when you're under pressure. But good lawyers do that, as I said, day in, day out. So it's probably not an answer to what wasn't a question.
I believe we have another question.
I just wanted to ask, there's been a a growing trend for a variety of reasons for advocates to obtain medical reports, particularly in relation to mental health issues, not necessarily very severe ones, where in the past you wouldn't. Does that really make a difference to the courts in your experience?
Yeah, I touched on that before because I've always had a real interest, intellectual interest, and personal interest in psychiatry and psychology, because I've been in the profession for so long. I've seen how DSM, well, it was DSM-2 when I first started. It's now DSM-6, I think, and how they categorise something as a mental illness in one manual, and then by the next manual it's not. And really, it's got to almost a nonsensical stage. I remember doing a sentence of a young man that had punched someone in Hastings Street in Noosa. It was a compensation case, and back in the day when we did compensation cases, and the victim had something called place-specific phobia. As a result of being punched in Hastings Street, he just couldn't bring himself to go to the nightclubs in Hastings Street after being place-specific. There it was in DSM. And I said in my paper that one of the areas where it doesn't help is where you have these long, discursive reports talking about all the tests which lead to nothing, lead to no diagnosis of mental illness. And there are some judges that are testy too about whether a psychologist is qualified to express an opinion about, for example, a psychotic disorder or a schizoid disorder. But if it's only for the purpose of setting out your client's antecedents, it's problematical because it takes so much time to read and digest. And really, that's the story from the punter's point of view. And often they say things and they're recorded in the report that aren't helpful and can be quite prejudicial and can affect issues like remorse. So inherent, I think, in your question is that you probably think it's overdone, and I agree. I just think unless there's clear evidence, and that is evidence of a pre-existing mental condition, such as major depression or bipolar disorder, whatever it is, then getting a psychologist to sort of write a long report talking about all these tests that have been done, psychometric tests that have been done, which really produce a result to say this person's an alcoholic or they're drug dependent, when that's obvious, is not all that helpful and can be counterproductive.
I think probably the reason I did raise that question was that it seems, I get the impression that very often advocates these days are almost afraid to put things forward without having the backup of medical reports, even if it's just about anxiety, depression, alcohol or drugs. Yeah. And therefore we're in this cycle of getting expensive reports and almost allowing the medicos to do the submission rather than what used to be the advocate's role.
Look, I understand that, but I think it's problematical. I mean, speaking for myself, I always found a short, succinct report from a general practitioner who knew the person and had treated them for a lengthy period of time a lot more effective if you're trying to get across a dysfunctional, problematical lifestyle as part of the explanation for what he or she had done. I found that to be a lot more effective usually than a long psychological report. I mean, reports, this happened, GP reports being handed up on a sentence hearing, X is unfit for duty for the next 3 days. I didn't find that particularly helpful, particularly when it was out of date by about 12 months. It's amazing what people do.
Thank you very much.
Thank you.